Liisa, do you want to say a few words and then talk about Ausome?
Sure. Thanks, Ken. So my name is Liisa Vexler. I'm the executive director and co-founder of Ausome. I founded it with my husband actually 3 years ago in 2015. We are a registered charity. And our goal at Ausome is for families touched by autism to play and be physically active just like typical families. Well, why, you might ask? Because we believe that play and physical activity foster three things: courage, connection, and community. They reduce social isolation and allow us all to be healthier and happier and more fulfilled. So at Ausome, families benefit from being part of the Ausome community. And how do they do that? Well, I have four ways that families can benefit from being part of the Ausome community. So the first thing, children and youth with autism can learn the physical literacy skills. Those are the skills they need to run, jump, and throw with other kids on the playground or in their backyards. And they can develop their courage muscle, I say, learning to take more risks in a safe and supportive, sensitive environment for free, because we know the financial burden is already big enough for families. Second thing that families can benefit from, children can participate in sports programs like soccer, basketball, gymnastics, and even water polo, where they will be met where they are and with a respect for who they are, also for free. A third thing, parents can drop off their children without worry that they will be embarrassed, feel ostracized, or left out. They can take that worry-free time to connect with other parents who may have similar experiences or commonalities. They can do this at our regular 6 to 8 week sports and recreation programs, or they can do it at our week-long summer and March break camps. And the fourth thing, finally, coaches and instructors in the broader community can receive training from Ausome on how to work with athletes with autism and best support them in their community teams and programs. Soon, these trainings will be available not only in person, but also online in 2019. This is all in an effort to create a more supportive, inclusive, accepting community for families living with autism. So again, our three words at Ausome are courage, connection, and community through sport. I want to thank you, Ken, for inviting me here today to share my passion for inclusion for children with autism and other special needs. Ausome is founded on the principle that sport and physical activity are rights in our society. They are part of a healthy lifestyle, providing both physical and emotional benefits. Through Ausome, we have a vision that someday all children will have the tools and the opportunity to grow up, to be healthy and active for life. Another part of a healthy lifestyle is stress management. One surefire way to manage stress, and this is one of my favorite things to do, is to plan, and sometimes have several backup plans. At this point, I'm going to turn this over to Ken Pope, and Christiane Marchand, who are by far the most expert planners for parents of children with disabilities, or my preference, different abilities that I know. So Ken, Christiane, over to you.
Thanks very much, Liisa. That was awesome. I couldn't help myself.
Yeah, thanks. I've never heard that before.
Thought so. Well, I'm very pleased that we have such good turnout this evening. This is, in fact, slightly below average, but that's just fine. The seminars are always well attended. I think that the thing that people would like to know a little bit about first is the recent announcements by the Ford administration. And firstly, I'd like to reassure everyone, we haven't seen anything yet that is negative for people with disabilities. In fact, the employment side of it is improved. And I've just got the proof for the first draft back from my next article about this, and it'll be included in the next newsletter, which I imagine will go out next week. So if you've signed up for the newsletter, then you'll get all of the actual numbers here that I'm putting together for you. Simply put, people that have disabilities would like to work. That's completely consistent with the new conservative government's approach to life, that the cure for poverty is a job. And it's also recognized, of course, that people with special needs need some accommodations, some more than others, and often can't work full-time, or can work full-time but then have to take a break. So what's happened is the old rule was that for employment income, if you worked, you'd be given an extra $100 a month, and the first $200 a month was exempt. And after that, every dollar, you lost 50 cents. So under the new rules, the first 6,000 is exempt. And if you were to calculate that on the first 500, if you're working and making 500 a month, let's say 125 a week, then under the old rules, you would make 500, you'd be given an extra 100. The first 200 are exempt, that's 300. And then the next 300 of earned income, you lose half of that. So your net is 450. Whereas, of course, under the new regime, 500 is 500. And 600 is 600, and 700 is 700, and up to 6,000. So I think simplistic, that's more simple than before, and it's more money than before that's exempt, however you count it. Now, if you go to the far end and you say, oh, yes, but won't people be cut off sooner? Well, nominally, yes. Under the old rules, the calculations are all in my my article that'll come out. But under the old rules, you didn't lose ODSP until you had made $30,456. And under the new rules, the maximum is $24,704. So it is 6,000 less, no question about that. But to put it in perspective, if you were working an 1,800 hour year at a minimum wage of $14, that's 25,200. So it's $500 more than the cutoff point for ODSP, just to put it in perspective. And the bigger fear that people have, and I have to tell you, we had this same fear back in 1998 when the Harris government was going to amend the legislation to change it, and did change it, from family benefits to ODSP. And at that time, what happened was the Harris government changed the family benefits disability qualification from permanently unemployable, meaning useless because you can't work, to, if you read the preamble to the legislation, a sharing of responsibility between the community, the province, the community, the family, and the person, which I think is pretty reasonable. And the test was can't function in a competitive workplace, or in the community, or handle personal care. So I saw that as an improvement. And it was the Harper government, federal of course, but it was the Harper government and Mr. Flaherty that brought in RDSPs. And his wife, he's deceased now, but his wife is the Vice Premier of Ontario. And they have a child with special needs. So, and we know, of course, statistically that 1 family in 10 in the province has a child with special needs, conservative or liberal. And we also know in particular that there are other families, other named families, who of the MPPs who have kids with special needs. So I don't think it's going to be a big issue. I think that the focus is going to be more on Ontario Works and seeking to motivate people on Ontario Works rather than people with disabilities to have any kind of special cutoff. It'll be very interesting to see. I could be wrong, but historically that's what happened. And the reason is that conservative governments are more focused philosophically on the family, and the family giving support, which it does, to the children with special needs. Whereas from a more liberal so-called perspective, it's more of a nanny state approach, and how much handout can you give or not give in the case of the meager amount that ODSP amounts to. I also think that what the new administration will do is make the rules much simpler and clearer for unlimited support from all sources for people with special needs, rather than the present, even the present 10,000 over 12-month gift rule. So it'll be very interesting to see. I mean, from a public policy standpoint, why would you restrict the amount of support that can be given to someone with special needs? It just doesn't make any sense. Let me just see if anyone's has any specific questions about those items.
There's a lot of questions right now about RDSPs, Henson Trust, and ODSP.
Okay, so I'll just get into the session, I think, then.
Okay.
So this just says if you need a free family assessment, fill out the form under family evaluations on my contact drop down on my website. And there's a free ebook if you'd like as well. These are just some interesting numbers. You'll see here that if you add up the total numbers here, these numbers total this number, 362,286. Those are that as of 2017. Those are the numbers of people on ODSP between the age of 18 and 65. It doesn't count all the children under 18, and it doesn't include all the people that turn 65 and start then to receive old age security and income supplements, which, by the way, are more than ODSP. They total approximately 17.4, plus there would be some element, in some cases, of CPP, compared to 13,800 for ODSP. But if you see these numbers, Ontario's population is approximately 13.7 million. And what StatScan says is that if you divide the number of people by 3, that'll tell you approximately how many households there are. And so this means there's approximately 4,566,000 households. Now, if you look at the 362,286 and round it up a bit, because the kids under 18 and the people over 65 are approximately another 1/3. So this brings us up to approximately 456,000. So what that indicates is that 1 family in 10 is the parent household of a child with special needs of some age. And of course, these people with special needs, the kids, are just the children of their parents for all their lives. If you have a child who's born with special needs or disabilities, and you care for them at home until you die, well, they are still your little boy or your little girl all of that time. The standard refrain is, I just want to live one day longer than my son. And although in most cases this won't happen, hopefully, it does happen. But then, of course, you have to make a provision for the fact that generally we hope that parents will live longer than their children, and usually they do. I'd like to just touch on this number, Borders, 46,871. That's the number of people who are on ODSP who are still at home or living with families, such as brothers and sisters, primarily parents, but also when the parents have passed on, it would often be the brothers or sisters. Well, when we get to the ODSP benefit amounts, these are all the people that get the lesser amount. These are the ones that receive the room and board amount. So we'll get to that in a moment. Now, if a person, for those of you whose children are under 18, when your children turn 18, they will then quite likely qualify for provincial benefits, and they're largely the same in all the provinces, although they do decrease and they are more restricted in the Maritimes. You have to reach out to family, extended family, further in the Maritimes than you do in Ontario or BC, for example. Ontario and BC are very similar as far as benefits are concerned. We'll come to the numbers in a second. And the primary concern for my client families, and I have approximately 5,000 families where we've done their wills, which seems like a large number, certainly enough, you know, at present, but it's interesting for me because if you see this number, and you can see that the numbers of families I've touched are only approximately this number. There's still a lot of families that need my help out there.
Ken, Adam is asking, what is the difference between renters, renters private, and renters subsidized?
Subsidized would be the, I'm sorry, wrong one. Subsidized would be the geared to income, and private would just be renting. Now, they might well be privately subsidized by their parents, but these are just, and this renter number here, you can see this is a total of those two. It's somewhat deceptive the way it's laid out, but now you can clearly see now that the 279 is the same as the total of the other two numbers. I would have thought that there would be more subsidized. I'm surprised, actually. So the main question that my clients have is what will happen to my child when I'm gone? And what we deal in here, ostensibly this is a law office, but what we deal in is peace of mind, a sense of security, a sense that you've done all that you can do. And we do that largely with wills with Henson trusts to provide for the child. We also help with future planning and estate planning and financial planning and issues like life insurance to fund the trust. We'll get to that as well. RDSPs for the child, that's their own asset. Registered funds, RRSPs and RIFs and rollovers to lifetime benefits trusts, and we'll get to that. And Christiane, if you just keep an eye on interesting questions and let me know, I'd appreciate it.
Okay, well, do you want to touch on a couple ODSP ones?
Sure.
Colette is asking, since the ODSP asset limit increased from 5,000 to 40,000, can they now invest in TFS without affecting their ODSP income?
A person can have an asset in a TFSA up to 40,000. You'd want to keep it below 40, just to not go over the limit. But yes, you could certainly do that. And a TFSA is an excellent idea, especially if someone has a certain amount of money, perhaps from a small inheritance. Because when they reach 65 and they get old age security and guaranteed income supplements, income from small investments or small inheritances that are not in a Henson trust, we can protect up to 100,000 from a death outside of a Henson trust. Then the income would a dollar of income would offset 50 cents of the guaranteed income supplement. The guaranteed income supplement is approximately 10.4. And so as a result, if you had $1 of income from a modest inheritance, the income, what's the sense, really? Because you're going to make $1 of income and lose half of it. It's like being in a 50% tax bracket. And of course, the TFSA would deal with that, because the money drawn out of a TFSA, which is grown inside the TFSA, is not income and doesn't affect the GIS. Any other questions?
Sue Davidson is asking, what about annual reviews for ODSP?
They don't really presently happen. You can say what you want about annual reviews, but I'm not aware of any annual reviews. No one has ever called me to complain about an annual review. Now, these are the benefits at present. They change slightly every year. You saw all the big hullabaloo in the paper about the promised 3% and the reduction to the 1.5, which it had always historically been. So the campaign promise was not, of the Liberals, was not carried out by the Conservatives, because it was never implemented. It was simply a campaign promise. But you can see here that the room and board amount is $869. It should be $896. Would you correct that next time around, Christian? So it's $869. So $896 is the room and board amount, and $1169 is shelter plus supplementary benefits. And if those 46,000 kids that are living at home could shop or cook, or could pay to have cooking done for them, or if they happen to be in a gastro tube, or if their diet was restricted to protein drinks, or if they were in a fully supported living situation where all their food was provided, under every other scenario, except that mom and dad make the food for this child, they would receive the $1169. It's only the parents making the food for their child that results in the child receiving the lesser amount. And of course, in a lot of these cases, it's because the child needs more levels of care and stays at home with them because they couldn't find the care anyplace else, which I think is very interesting and very inequitable. So we do our best to get these benefits increased whenever we can. We've done it approximately 283 times. I'd love to do it 46,000 times. But even the 283, if you take the 270 a month increase and make that an annual amount and multiply that by 283, you'll see that it comes out to be more than $1 million a year. So in our humble way, we have been able to increase benefits for our client families by over $1 million a year. And I'm proud of that. I'm very pleased to help the other 46,000. We can also exempt assets. You'll find certain situations where people come into money in various ways. Sometimes after the third child, a mother has postpartum depression that doesn't go away. The couple breaks up. The father stays in the home with the 3 children. The mother leaves and goes on ODSP, but eventually she receives her half of the value of the matrimonial home. Well, until recently, the asset test was $5,000. So, of course, almost any amount would disqualify her from ODSP. But we have ways of exempting up to $100,000. And, of course, the personal asset test is now $40,000. Are there any questions that pop up about that?
Sorry, I was muted there. How do ODSP recipients apply for subsidized rent?
Well, you put yourself on a housing list. There's usually 1 or perhaps 2 housing lists in your community. Now, as long as you're either safely at home with family or destitute but safely ensconced in an apartment or rooming house someplace, you won't go anywhere on the list. You'd have to be in some kind of a crisis situation where you're being evicted, or your parent has died and now you have to leave the home because it's being sold by the estate or something like that. I suppose it's possible that you might be able to live long enough to get a geared to income unit, but you'd have to Methuselah in most cases. Also, to tell you the truth, a lot of these units have been taken up by, it's like a triage system at any emergency room you've ever seen. Somebody comes in that's bleeding from the throat, they're going to go in first. So all of the irregular migrants that have come to Canada, of course, they have first call on a lot of this stuff, especially if it happens to be a family group. You know, those families that have come in properly, if they come in as a family, they also get a higher priority. That's how life is. So if you're an individual, it's pretty tough.
Brenda's asking, can someone have 140,000 and still collect ODSP with the new rules?
Yes, they can have 40,000 as a personal asset, and then the other 100,000 we can exempt in a couple of ways. Depending upon the source of the money, whether it was an inheritance or a small windfall of some sort or a gift. But yes, we have ways of exempting up to 140. And then, of course, if you happen to qualify for a registered disability savings plan, you could shelter a further 170 and still be able to make the 30,000 contributions, which we'll get to in a moment. But of course, if you put it in, you probably can't draw it out until you're 60, but it would be sheltered.
An anonymous question. If a relative owns a condo and charges a reasonable rent, much less than market rent for a person living with a disability, would this be acceptable housing and not impact their ODSP?
Well, if a relative or someone provides you with rent and accommodations and it's below market so that you can afford it, if it's say it's the $500 that is the shelter component, this is perfectly legal. And in fact, if it's being provided for below market and the person is not in pursuit of profit, they don't have to declare it as income, which could be helpful. Similarly, though, they can't write off expenses on that unit, because if you're not in pursuit of profit, you don't have to declare the income, but you can't write off expenses. What's the rest of that question?
Where did it go? If a relative owns a condo and charges reasonable rent, less than market, would this be acceptable and not impact the ODSP?
No, this would be no problem. As long as you're paying at least the shelter component amount, which let's just say it's $500. As long as you're at least paying that shelter component, then you're fine.
Are there shelter care or care options for people who can't physically take care of themselves but don't have family willing to help?
Yes, definitely. And if you can make your situation a critical situation where you have no supports and you need critical care or substantial care, then it is possible to move yourself up the list. My experience with the kind of in-home supports that are available from Community Care Access Center or the LINs or other sources are actually pretty modest. You know, people that are paraplegic or quadriplegic that get somebody for 4 hours a week so they can have a shower and go under the building. I know that wouldn't be uncommon. It's atrocious, actually. But yes, you could then receive supports. Now, what we do very commonly is we recapture tax credits, disability and caregiver tax credits. And the disability tax credit is the credit that belongs to the person if they are markedly restricted or can't set and keep goals, or can't handle personal care or feed themselves or toileting, or those sorts of blind, as the person is vision impaired or hearing impaired, mobility impaired. Those individuals would qualify for the disability tax credit. And what it does is it reduces taxes, if you pay taxes, by $1,600 a year. And in most scenarios, of course, people on ODSP don't pay taxes. So as a result, it's transferred to some supportive family member who does pay taxes, often a parent, sometimes a sibling. And it can be transferred if they help with food, shelter, clothing, the necessities, not completely, but in part. And if they haven't in the past, then they could in the future and use this credit. They could commence helping to some degree. But the most common profile that we find is that the disability credit is not used, has not been used, or they used to use it, and then when the child went into supported living, they stopped because they thought the child had to reside with them. So we identify this. We often have to put the T2201 back in place. That process takes about 6 months typically. And then we do the tax adjustments, and they could take 6 months as well, although we're just now working on a more expeditious online procedure that should help a lot. And the most common recapture is $16,000. Now, this money is recaptured by the taxpayer, not the person on ODSP. So they're the party that retains us to do this work. And then, if the person is approved for the disability credit, then they can have a registered disability savings plan. And if they're under the age of 49, if they contribute $1,500 a year for up to 20 years or up to age 49, the government puts in $4,500. And that's composed of a $1,000 bond that you receive each year, even if you make no financial contribution. And if you put $1,500 in, you get a further $3,500, which is substantial. And the money itself, of course, is invested. It belongs to the person with the disability. It's not like an RRSP or an RESP that is set aside for someone, but is owned by someone else. The parents can be the account holders for a child who is not competent, or with the use of a power of attorney, they could be account holders for someone who is competent but wants them to handle it. And if they are not competent, then and there's no parent around, it would be necessary for someone to have legal guardianship of the child, which is an application to the court that we do to have one or more parties appointed legal guardians who then become the legal representative of the child. You got any good RDSP questions there?
At what age can one start using money from an RDSP?
Well, the grants and bonds, the $4,500 portion, doesn't lock in until 10 years after contributed. So after you contribute $1,500 and the government puts in $4,500, 10 years later, which is this year or next year, for the plans, they all started in 2008. So if you started the plan in 2008, made your contributions, next year, 10 years later, is the first time that the $4,500 is locked in. And there's no present ability to withdraw unless you happen to have some anticipated foreshortened lifespan. So the simple answer is that the money is supposed to remain in there until you're 60. And then there's a plan, a formula for how it comes out. Unless you can show that you do have a foreshortened expectancy of life, in which event there's another plan for how it can come out sooner. But nothing at all could be paid out at least until next year. Now, I fully anticipate that in the sessions next year, we're going to get this question much more. And one of the very next articles that I write for our newsletter will be about this, because of course now it's finally timely to start talking about this. When could money actually be withdrawn? Now you can see, of course, that the plan wasn't that you'd put in $1,500, get $4,500, and then take out $1,500 to contribute $1,500 to get $4,500, and so on. So it's pretty obvious that that was not what was anticipated. And so you have to have some sort of vesting period, which is a 10-year period.
Is it possible to transfer RESP to RDSP if the child is not able to pursue post-secondary education?
It is possible to do that. And there is paperwork which would allow you to roll it over so that the grants that have been provided are included in the rollover. But what you have to do from a sort of practicality perspective is look at how much is the government contribution. What would you lose if you simply withdrew the money? Because, of course, you can always take out your contributions at any time. It belongs to the contributor. And the only difference is the maximum $500 a year government grant. The growth portion would also be paid out to you, and it would be income. So you'd have to look at what is the growth amount and what would the tax effect be to decide whether you would simply withdraw. Because, of course, if you roll over, you're rolling over the lump sum. And while you would then perhaps still continue to have the $500 per year grant and the growth not being taxed in your hands, because of course the contributions are just your capital, there's no impact either way. But if you made the lump sum rollover, you only get the matching $3,500 once.
I have a couple questions here touching on the same thing. What happens if someone loses their disability status and can't get it back?
Well, you should keep in mind that you have, if you give notice to the RDSP holder, you know, whether it's the bank or Mackenzie Financial, if you give them and Service Canada proper notice that you're going to be seeking the reinstatement of the credit, you have up to 5 years to get it reinstated. But otherwise, the plan would collapse, and the money that was contributed would be given back to the child, not the parent. And of course, the grants and bonds would all be returned to the government. But of course, this would only be in the situation where if you have a time-limited disability credit that you've been granted that's good until 2020, that if you apply again, it's unsuccessful. And of course, we can assist with this, because what you want to do is to make sure that the paperwork that is submitted is sufficient and correct so that it is granted again. But this is a problem. It can be a problem.
Similar question, but I don't think I've ever heard this be asked before, but what happens to RDSP money if the account holder passes away prior to age 60 and nothing's ever been withdrawn?
The money falls into their estate. And thank you for that question, because it's exactly where we're going. Because obviously what happens if the beneficiary, the child who owns this RDSP, what if they die? Well, if they die before the grants and bonds are locked in, then the grants and bonds are returned to the government, and let's say it was, God forbid, but it was this year. Well, the $15,000 maximum contribution would be paid back, and if the child had a will, it could go to whomever he willed it. But if he doesn't, then by intestacy and succession law, it would go first to his parents and then to his siblings. And if the siblings are gone, then to their children. But if he has no siblings and no nieces and nephews, then it would go up the ladder, potentially up to his aunts and uncles, the brothers and sisters of his parents. And if none of them were surviving, then down to his cousins, who may never have come to visit him. How's that for an answer?
That's good. Now that you have guardianships up, Phyllis is asking, how do you get powers of attorney or guardianship for an adult child who is nonverbal?
It's easy, sort of. What you do is you have a little chat with me, and we determine if we're content that the child is not capable, incompetent. If they are, then it's soft and clear. So the procedure is you have to make an application to the court. We do these applications for the clients all over the province, filing them in Ottawa, because it's a jurisdiction of the level of court, not the jurisdiction of where the guardian or the person lives, as it would be, for example, for probate. And there's no appearances in court. There's a very small court filing fee of about $250. You have to pay the public guardian about $250 to review the application. But it's a big spiral-bound book, quite heavy. And everybody has to be served with this document with affidavits and statements and the plan of care and the management plan. And, we of course prepare all that. But then you have to have 2 capacity assessments. And the capacity assessments cost these days approximately $1,200 each. And then there are, of course, legal fees. And we have standard fees for this work. So whenever we can, even if the child is nonverbal, we try to determine if their level of competence is in fact sufficient for them to sign a power of attorney. And the way this is done is capacity, competence, is very interesting. It's not just a set limit. So if you had an X and a Y scale, and I guess let's say this is X, this is cognitive ability, and this is capacity, and this is also complexity. So if your cognitive ability is sufficient for the complexity of a given task, well, then you are competent for that function. And competence is a function-specific thing. So the test for personal care is lower than it is for property. For personal care, the way we look at it in a very practical way is if you speak with your child and they comprehend you, and of course if you're their parents, you comprehend their communication much better than anyone else. And if you ask them, if you were sick and you were in the hospital, who would you want to make sure that you were cared for properly? Was it mom and dad? And if they could answer this and they could comprehend it and answer properly and not just respond yes to whomever you might suggest, then they're probably competent to sign a power of attorney for personal care. At present, you can be the account holder for their RDSP, which is their only real property. And of course, you can be their ODSP trustee. There's no issue with that. The problem that comes in is when you pass on, who will be the account holder when you're gone? No one has the legal capacity. So you would need guardianship to have successor guardians, such as his siblings. And we'll get into this in a moment, but a lot of children will stand to inherit pensions from their parents. Adult dependents, survivor parents from teacher parents, municipal employee, owner's pension parents, and OPG hydro power generator parents. Well, who is going to apply to get that pension for the child, and who will manage it for them if they're not competent? So, we have this discussion. and we decide on balance whether cost-wise and convenience-wise this is a good thing. Is it part of the plan for the child? Does it deal with the succession provisions for this child? Is it one more thing that you're doing before you pass on that you're not leaving to the people that will be the trustees for your child? It's that kind of discussion. And of course, the parent is the substitute decision maker for the child in default of powers of attorney for personal care. That's another discussion. Wouldn't be unusual for us to have to do a substitute decision maker bundle that looks very official and legal to make sure that the doctors and hospitals actually pay attention to you if there's critical issues. Any questions about that? So that brings us to pensions for adult dependent children. There are statutory provincial pensions. And these are the pensions for teachers, municipal employees, hydro workers, power generators, Bruce Nuclear. And the other provinces have similar pensions. They're all provincial, statutory, unionized pensions. And what they provide is that you have a pension when you retire. When you die, your spouse receives 2/3 of your pension. And then if you have an adult dependent child, and at the time of your death, they are adults and dependents, then they stand to receive 50% of your pension. Now, for a teacher with a $60,000 pension, this would obviously be a $30,000 pension, which is more than ODSP, so they'd lose ODSP, but they'd have a $30,000 pension. Now, they would probably still need the Henson Trust in the will to manage the inheritance. They just wouldn't need it to protect ODSP. And of course, if this child is not competent, then someone has to be their legal guardian to apply to get the pension. A common misconception or question that people ask is, can I just have the pension paid into their Henson Trust? And no, because it's their pension. The trust receives your estate or your life insurance. It's very interesting as well because the RDSPs, when the child is 60, could well be $400,000. And if they then die and they're not competent to do a will, well then by intestacy, it falls down to their siblings or their children, if any, and if none, then up and over and down to the cousins. And the same thing would happen with the accumulated pension, because if the pension is $30,000 and after tax is $27,000, and even if we replace the ODSP amount of $1,000 a month that's being paid to Carrie's place, for example, well, even if we did that, that leaves $12,000 from 27 and leaves $15,000 a year. And that child simply doesn't need or can't use $15,000 a year. So what happens is the sister, who's the guardian, accumulates it, invests it for the 20 years further that the child lives, because now he's 54 when his mom dies, and he lives for another 20 years. And it accumulates at the rate of 15,000 times 20. So now it's 300,000 plus growth over 20 years. So he dies intestate with no will. When he dies, the guardianship ceases, just like a power of attorney. And the sister, who is the guardian, who is now no longer the guardian, applies to the court through a probate process to be appointed the administrator of his estate. And then by succession law, she's his only sibling, and so she gets all the money. And the same thing will happen with the RDSPs.
Karen is asking, if I have a pension, do I need to identify my son now in order for him to be eligible later?
Well, my guidance on these things is that you should write a letter to your pension people now. Put your child on their record, give them the SIN number, date of birth, nature of the disability, perhaps some sort of supporting paperwork, because I'm sure you have it, and ask them to send you a letter to advise you how the child could qualify for the pension upon your demise. And they'll send you a letter, and I've seen the letter, that the child will have to be approved at that time, and their doctors will have to be involved, and so on. But you can put it on the record. You can do what you can. You can leave plans for your executors and the trustees of the trust and the guardian, if there's legal guardians, to deal with this when you're gone. And at that time, the child would then start to receive the pension.
Does pension inheritability, such as OMERS, apply to adult foster children?
I'm sorry, say that again, please.
Can a foster kid inherit an OMERS pension?
If they were adopted. I've never tried to have someone who's in a sort of a custom adoption receive the pension, but if they're an adult dependent that you've treated as a child, we'd have to look at the definition of child in the particular pension plan. And of course, you could always adopt a child.
Yeah.
That would be the simplest recourse.
There's a question, do federal government pensions have stipulations similar to the ones you're discussing for provincial?
Regrettably, no. Some private pensions do. I'm familiar with situations where Bank of Nova Scotia and Aviva Insurance, for example, where the spouse had predeceased, and there was a pension for a dependent, a surviving dependent. It was intended for a spouse, but we were able to have it applied for the child instead of the spouse. But federally, no.
If an adult child is receiving the mother's pension due to her death, how long do they receive it for?
Well, a child would receive, typically if they're in school, up until age 25. But there are a lot of these pensions that if it was a pre-existing disability, then it goes on forever. That would turn, of course, upon the particular pension plan.
One more. Can a municipal pension that went to a widow go to their disabled child that's on ODSP after the widow dies?
If it was an OMERS pension, a municipal pension, and it's passed on from the deceased husband to the widow, then yes, it could, 50% of the original pension of the father could pass on to the child. Now, the problem, of course, with a lot of OMERS pensions is that they're more modest pensions, and the amount that the child then receives is less than $11.69. So all it does is offset ODSP. Now, what I'm looking for is the opportunity, and if the couple who attended my Picton seminar in, I think it was March last year, if they happen to be watching, they were both OMERS, both municipal employees who were not retired, and they have a child with special needs. So the pension from both of them would pass on to the child. This would be the same as well for teachers, because a lot of teachers marry each other. You do find your spouse sometimes where you work. And of course, then the child would get half of each pension. But back to this one, say it was $500 a month, half of $1,000. Well, that's just going to offset $500 a month of ODSP. But if we plan in ahead of all this, it is potentially possible to commute the child's pension to a lump sum. Because in most of these cases, this is an unfunded liability for the pension plan. They hadn't really planned on these kids. So if a child was going to receive $6,000 a year, and it was expected that he would live another 30 years. That's $180,000. Suppose we were to cut a deal for $100,000 lump sum, or $50,000 lump sum. What it does is it crystallizes the liability for the pension plan. It gives my client's kid $50,000 or $100,000, which we then proceed to exempt. And instead of the annual payment or monthly payment offsetting ODSP, it would proceed to assist them. I'd love to do that. I just haven't had the chance to do it yet. I'd like to talk about RRSP rollovers. And we have 2 new slides, I believe, eh? In most cases, if you have an RRSP or a RIF and a surviving spouse, of course you designate that to your surviving spouse. But if you don't, if your spouse is deceased or you're divorced, then if you die and the RRSP falls into your estate, you pay taxes at your rate, often at a high rate. Well, it is possible. There's a new tool called a Lifetime Benefits Trust, which allows you to roll over to the trust, just like to a spouse, for a single beneficiary who must have cognitive disabilities. It's not sufficient for them to have physical disabilities. They must have cognitive disabilities. But if that is the case, then it's possible to roll over to the Lifetime Benefits Trust, hereafter LBT, and the only thing the trustee of that trust can do is buy a qualifying trust annuity based on the life or expected life of that beneficiary child. So I'll give you some examples in a moment. So what happens is the annuity payment, which could well be underwritten based on the child's life expectancy, just as per our discussion about the RDSPs, which would increase the amount of the annuity because they're expected to live a shorter lifespan, if this is the case. It would purchase an annuity with payments to the trust. So of course there's no effect on ODSP, but the income is automatically declared, must be automatically declared in the hands of the beneficiary. But of course the beneficiary has tax credits, approximately $20,000 worth of tax credits. So the first $20,000 is not taxed. And we'll come to those examples in just a second.
It's the next slide, I believe.
Excellent. So this is a Lifetime Benefits Trust sample.
There's a second sample on the next slide. I added 2.
Excellent, thanks.
You're welcome.
So you can see here that the value of the RRSP or RIF at death is a modest amount. It's $500,000. And if the client dies in December, and all of their other income, plus perhaps income from a deemed disposition of a cottage or any stocks, those kinds of things, if they're then in a top bracket, they would lose half of the money to taxes, $250,000. If instead they designated it to the Lifetime Benefits Trust, it would roll over and be put into annuity, and the child would be age 58. And you can see that the $500,000 purchases an annuity, which is guaranteed for 20 years to make sure that we get all of our money back. And the annual payment is $24,864, almost $25,000. And if you multiply that by 20 years, you get $500,000. So you're guaranteed you're going to get it all back, even if the child died less than 20 years later. And because the child has personal and disability tax credits, the taxable amount is $4,864. And the tax on it, at 22%, is $1,070. And a total of 20 years is a total of $21,401. This is a savings of $228,000. Now, it's not rocket science. It's just a new tool that is barely known, that I've been following and finally implemented last year. It first came into potential existence in 2003. and then finally received royal assent in 2013. But of course, you have to have a clientele that's large enough to have enough clients to benefit from this, to be able to invest the time into the research over the years and the drafting and the confirming and the getting to the point of satisfaction where you know that the thing will work, and then actually putting it into play. Now, the Lifetime Benefits Trust is a separate parallel trust. It is not a Henson trust. It's an absolute discretionary trust, but it's not a Henson trust. And it holds only, in my structures, it holds only the registered funds. This is the second example. You can see that the RIF is approximately half of the original, the first one. It's a 275. And if you have it come into income and pay half in taxes, you pay $137,000. But if instead you roll it over to the LBT with the 21 guarantee, it pays $13,200 a year, which returns the 275. And because there's more tax credits than there is income, there are no taxes, and the savings is the total of $137,500. Kind of neat, eh? So I think this is great fun. Are there any questions about that? No questions?
Yeah, there's a couple questions here. Once you reach RDSP rollover limits, this makes a lot of sense. At what point does the size make sense to set up LBT? James is asking.
Well, you're right that you could roll it over directly to the RDSP up to a total of 170,000. And that is a tool that we would always discuss, of course. In fact, you could roll out 100,000 directly to the child, and we could exempt it as an amount flowing from a death. But in both of those cases, it becomes the property of the child, which means that, firstly, it's the property of the child. You know, is this the intention? Or do you want it to be a piece of property that is managed by a trustee, or must be managed by a trustee because the child is not capable? And even if you did roll it over to the child, even if you did have legal guardians to consent to the rollover directly to the child, and then it was then put into an RDSP to shelter the 170,000, it's still the property of the child, who then dies intestate, and it passes to his cousins. Whereas the father who died might like it to be held in the LBT and to have the provisions of the LBT trust determine where upon the child's death the residue goes, rather than the cousins. So you're right, the rollover directly to the child for less than 100,000 or to the RDSP for 170 is possible. And as well, of course, if you roll it in at age 53, then potentially you can't withdraw without impact on yourself until you're 60. Whereas if it rolls into the LBT, it's available immediately, at least the annual amount. And there is also the factor that the annuity does guarantee those payments for life. You know, the guarantee period or life, whichever is longer. So the way we look at it is that where this is all on balance in the whole picture, the appropriate thing to do, what it does is it satisfies the fixed income component of the estate planning, because it means that this fixed amount will be paid for sure for life.
Jack is asking if there's a way to make an LBT into a Henson trust.
Well, this gets us into a rather sticky legal aspect, and I'll go into that. Thank you. I'll just touch on Henson trusts first, and then I'll touch back to the LBT and why it's not a Henson trust. Firstly, it would be possible to create a single LBT that received all of the estate plus the RRSP. But it's for various reasons, it's my practical decision to advise that there be the two trusts, one to handle the LBT directly, only the RIF, and then the other one to handle the rest of the estate. Because there are times when having two trusts is advantageous from a practical and also a tax effective perspective. But legalistically, the reason that you can't roll it into a Henson trust is this. A Henson trust has two aspects that are essentially different from a normal trust. They have an absolute unfettered discretion on the part of the trustee and a non-vesting provision as far as the asset. In a normal trust, the trustee has discretion, but it could be compelled. It is potentially possible that they could be compelled, and for that reason, if the trust is not an absolute discretionary trust, if it's purely a discretionary trust, and the asset exceeds $100,000, well then it disqualifies ODSP. So it must be an absolute discretionary trust. And then the Henson trust has a non-vesting provision. In a normal trust, the asset of the trust beneficially belongs to the beneficiary. It may legally be in the hands of the trustee, but beneficially it belongs to the beneficiary. Whereas in a Henson trust, it does not. No share of the interest or the income or capital thereof shall vest in my said son. And the only interest he shall have shall be the amounts actually paid to him or for his benefit. So it's not vested. And this is the critical point for me from a legal perspective, because for an LBT, it's a creature of the Income Tax Act. Trusts are not creatures of the Income Tax Act. They're creatures of common law, but they are treated as tax entities by the Income Tax Act, and the tax treatment is dictated by the Income Tax Act. And what the Act says is that it must be a trust for a person, a sole individual with cognitive disabilities who has a beneficial interest in the trust. And of course, the whole point of a Henson trust is they don't have a beneficial interest. There's a non-vesting clause. And I really don't want to get to the point where we've put this into a Henson trust because it seems like such a great idea. And then one day down the road, some smart guy at Canada Revenue says, oh, well, he has no beneficial interest in that trust. That doesn't qualify as an LBT. And obviously, they won't give us an opinion on that hypothetically in advance. Granted, I suppose we could seek a ruling, but I don't wish to go through that process. And I don't want to find to my disadvantage that the fact that there's a non-vesting provision means that it doesn't work. So it's just a whole lot simpler for my small mind to keep these two separate and clear. And there are also discretionary factors in keeping them separate. I mean, for example, you could direct that the residue of these two trusts go to different places. One goes to the family and one goes to a charity, for example. Or one goes to one side of the family and one goes to the other side of the family. And there are lots of internal family reasons. The bulk of the estate, for example, might have come from one side of the family, whereas the other side of it comes simply from the savings of the parent. And they may wish to keep that one side of the family inheritance on that side. It's all up to the discretion of the family. A common question about Henson trusts is, aren't they limited to $10,000 over 12 months? Used to be $6,000, remember that? Well, the rules were recently changed such that the voluntary payments over 12 months were changed from $6,000 to $10,000, and the asset test was changed from $5,000 to $40,000. And so the question I often get, I got it again just this afternoon, is aren't Henson trusts restricted to $10,000? And if that's the case, what good are they? Why would I leave that much money? Well, in fact, in practice, there are no limitations because what you do is you come up with an annual budget, for example, for the child, above and beyond the 10,000 and above and beyond expenses for disability-related things, because they're exempt as well. And then you make this calculation, for example, of the rental supplement of $700 a month, and you multiply that by 12, and you give $8,400 once a year, or every 2 years, or every 3 years, to the property manager to be used to defray the difference on the rent for the kid's apartment. And he continues to pay $500 a month, but the prepayment covers the difference. So, for example, that's one way to have it paid out with a minimal impact. There is an impact on ODSP for that single month. And in that single month, they would have been overpaid benefits. And this brings us to the topic of, well, in future, do we think that disbursements from this trust will be unlimited? And I do. Because from a public policy perspective, why would you block these trusts from providing further supports to the child? You're dealing with a child with special needs. You're dealing with, frankly, a pittance that's paid by the province. Why would you possibly block the family or friends from helping to provide additional supports for people? Any other questions about that?
Yeah, we got quite a few questions for Henson Trust. Can a Henson trustee be changed?
They can, and of course, that's part of the discussion as far as the planning for the will. We certainly provide a provision for the trustees to be replaced. And then as far as, that is to say, you know, upon the demise of the final trustee, or if there's always to be three, upon the resignation or death of one, there's a replacement provision. But as far as someone to see if the trustee is doing a good job, and if they're not, remove them, that would be called a guardian of a trustee. And you can have, it's not common, but you certainly can have someone who's the guardian of the trust, who may or may not be a trustee. They don't have to be a trustee. They don't have to deal with the day-to-day, but they could be the person that has been appointed to replace and remove trustees. As far as removing them by the beneficiary, well, unless this had been built into the trust, which it never is, no, the beneficiary simply cannot remove the trustee. You'd have to, the only way to do it would be you have to prove evil intent, mala fides, and that's virtually impossible, because as long as the trustee pays out something, and it can be shown they're exercising their discretion in some way, or they have simply done nothing, but they have not done anything to indicate that they've done this in an evil way, then they can't be removed.
Should you have more than one trustee?
If that you have that luxury, yes.
Can an annuity be purchased on the life of the individual with proceeds paid directly to the Henson Trust so that the individual's taxable income is not affected?
Well, if the trust is paying for it, and if what they're doing is they have a, let's say, an insurable interest in the beneficiary, or what they're doing is, as a part of their planning investment strategy, they're purchasing an annuity, but it is based upon the anticipated lifespan of the beneficiary, yes, they can. And no, we have a situation where we're just doing the final draft of a will right now, where there's a nephew who's on ODSP and who can't handle money himself, but there's really nobody available to be the trustee, especially for this particular fellow. And so what's going to happen as a compromise is the executor is directed to purchase an annuity for that person based upon their inheritance and their then expected lifespan, such that what they do is they get a certain amount per month for life. And, you know, frankly, what they do with it is their business, but that's all they get.
Can you please discuss how to roll over a RIF to an RDSP. Does the beneficiary have to be totally financially dependent upon the parent?
No, just dependent. They have to be, yes, dependent. And you can manufacture dependence or create dependence. We like to make sure that the disability tax credit or the caregiver credit is being used by the person, the deceased. The dependence test technically is initially a financial test, and if their income is less than the personal plus, if they qualify, the disability tax credit, which is $20,000 in total. If ODSP at the time is less than the total of those two credits, well, then financially they would be presumed to be dependent or dependentable, let's put it that way. And then beyond that, if they do happen to have income greater than that amount, because they're not, perhaps they're on ODSP and working, but still on ODSP, and they're making, under the new rules, less than $24,000, but more than 20, then on the face of it, they don't meet the prima facie financial dependence test, but that doesn't mean they aren't dependent. And then what happens is you designate it to the child, the adult child, and they then put it into the RDSP. And of course, there's paperwork and elections and separate paperwork to put it into the RDSP. And you'll find that the institutions that have these RDSPs and RRSPs don't have much familiarity because, of course, the RDSPs are still only 10 years old. And although some of the beneficiaries have passed on, the children, a limited number of the parents have passed on.
Does money from an RDSP or Henson trust affect GIS?
Sorry, say that again?
Does money from an RDSP or a Henson trust affect GIS?
The income portion, not capital, but yes, the income from any source would affect them. So, for example, this is a good segue into qualifying disability trusts. If you have $1 of income declared on your tax return when you're over 65 and you're receiving GIS, well, then you lose 50 cents. That's a 50% tax bracket. Whereas if your Henson trust has elected to become a qualifying disability trust because the beneficiary qualifies for the disability tax credit, well, then it can declare income in its own hands at the beginning marginal rate of 22%. So if you had a Henson trust which declared the income in its own hands at 22% and then gave tax paid capital to the child, that would not affect GIS. So instead of losing 50 cents, you'd lose 22 cents. Now, considering that GIS is approximately 10,400, there's enough here to think about. You know, instead of having income of 20,000 offsetting 10,000, you'd have 20,000 taxed at 22% and losing approximately 5,000. Testamentary trusts from a will can still purchase a home for the child, and if the child resides in the home, it still qualifies as a principal residence and is capital gains tax exempt. Whereas the inter vivas trusts that we set up until a couple of years ago to hold these principal residences, the home owned by those inter vivas trusts no longer qualifies as a principal residence. They got caught up in the recent change, October 2 years ago, which was intended to deal with people, non-residents, purchasing resident trusts and purchasing properties occupied by their children who are here in BC going to school. So the inter vivas trusts were disqualified from having principal residence capital gains exemptions. which is to the detriment of my clients' kids. Obviously, the bureaucrats who did this stuff didn't have kids with special needs, but that's not news. I'm sure they didn't mean harm, but it's just sort of roadkill in the process. But you can still die, or you can die owning a home that a child lives in, and there would still be a deemed disposition on the property when you die and taxes owing at that time. But if you left it to the trust for the child in your will, it would then qualify for the principal residence capital gains exemption. Any other good questions?
More Henson Trust questions, unless you want to keep moving along.
Yeah, I think I'll do this, and then I'll go back and scroll through. And if you check and see if these questions can stay up and available to me tomorrow.
Yeah, well, we can get a report of all of them, so we can reply to the ones we didn't get to tonight.
If I reply, how will people see the answer?
We would have to reply to them by email.
I see, okay. Okay. And I just, by the way, I see a lot of familiar names here, which is great. Thanks, guys. It's good of you to take part. So the reason I'd like to talk about this is, as a part of estate planning, we always discuss life insurance with clients, because life insurance, in the context of peace of mind, is a way to ensure that even if you have a modest estate or wish to create a greater estate for your child, you can do it on a very tax-efficient basis. And if you keep in mind that the first things we do is see if we can increase benefits for that 15% of households that have the child at home, which increases benefits or income to the household of $270 a month times 12. Or we try to put the disability credit in place at $1,600 a year, plus the caregiver credit, which I'll touch on in a second, and that's another $1,000. These amounts will pay an insurance premium, and they are generated in a sense by the child. Now, if you look at these life insurance, this quote, if you take a female, age 50, non-smoker, she has a life expectancy of approximately 35 more years. Now, to tell you the truth, if you make it to 85, you've got another 6.3. It all depends if you make it that far. But life expectancy, 35. Now, if you buy a permanent life insurance policy, as an example, that pays $100,000 on death, the monthly premium is $115 compared to $270 a month increase, or $2,600 a year divided by 12, approximately $200 a month. And that's a premium of $1,384 a year. Well, if you tried to save the premium every year to have $100,000, you'd have to do it for 72 years. So obviously you won't do it. And what this means is that your return on investment, if you die when you're expected to die, is very good. And that's all I have to say about that. The same kinds of calculations work for joint and last policies that insure both parents but pay on the second death. The numbers change slightly if it happens to be a term policy, term 20, and then you renew it and the premium goes up. But of course, with most of these term policies, when you turn a certain age, let's say 85, the deal's off. You know, the contract is over. And if you make 85, you've paid all those years, you didn't die, and that was your life expectancy. That's why it's 85. And part of the reason for this, the affordability of this, is that it's what's called the lapse factor. And that is that there's a whole lot of term policies out there that people have, such as at work, where they're covered until they retire. and they didn't die. And they paid, but they didn't collect, fortunately. Or they had these policies, and then by the time they're 62 or 72, they've decided that they're too expensive because they're term policies, and so they don't need insurance anymore, so they cancel. Only approximately 5% of all those term policies ever pay, meaning that people have died. Well, that's not a bad business if you can do it. And that's one reason that the permanent universal life and so on is affordable, because it's competitive in a sense with those policies. Now that brings us back to a small point, the caregiver tax credit. Where is that? Huh. Well, let's just use this slide. The caregiver tax credit is the credit of the person who's the caregiver. It is not the disability tax credit transferred from the person with the disability. And what it does is it reduces the taxes of that caregiver by about $1,000 a year. And we can go back a maximum of 10 years on a rolling basis. And as one of my friends online here has pointed out, if you don't use these credits in December, you lose 2008 in January. And the same with the contributions now to RDSPs. If you don't fully top up your RDSPs, you can only go back 10 years. And so you lose 2008, which is basically $4,500 if you don't contribute until 2019. But the caregiver credit can go back 10 years until the child is 18, because that's the age at which it comes into play. And until 2017, it only applied to people whose child resided with them. So 46,000 of 362,000. So what it did, for those that knew about it, and lots don't, is it reduced their taxes over the 10 years by about $7,000. Now presently $1,000 a year. But in 2017, the reside with criteria was removed. So now it applies, I would say, to virtually everyone. And the criteria is that the child is over 18, has a disability, and has income less than $22,000. That was changed too. The reside with criteria was removed. So what this means is the total number, in practice, 362,286 families probably qualify for the disability tax credit at $1,000 a year. That's 362,286,000. I think you can probably make out that number. This is a big number, and nobody really knows. So what I'd appreciate is if you'd let other people know about this. Look at line 307 of your tax return for 2017. In previous years, look at line 315. And if it's not there and you want to talk about it, give me a call or send me an email, because this is money that's recapturable. We're hustling right now. We're in the process of filing all the ones we can before the end of December, because if we don't do this, even if the disability credit has not yet been approved, we're going to proceed to apply for the credit, the adjustment, to hope that we can stay in the door for 2008. Because, of course, as of January 1st, it's 2009. It's 20 to 9. Do you see any other interesting questions?
Can you tell us more about the segregated trust that is exempt under ODSP? Are there restrictions on setting it up or putting money into it?
Well, and up to $100,000 received from a death, for example, can be exempted as an exempt asset received from a death. And you can make an appropriate investment in a segregated fund to exempt it as well. You can't do both. It's an aggregate of $100,000. And you get into the question of, should there be a trust in any event to manage the money? Or could the person manage it themselves? Could they be their own trustee? Because they could be their own trustee.
What happens to a Henson trust if the disability status gets denied at some point?
Disability tax credit has nothing to do with the Henson trust. Lots of people on ODSP don't qualify for the disability tax credit, but they still need a Henson trust.
Does the LTB flow through all income from the annuity for tax purposes to the beneficiary through the preferred beneficiary election? Does the income affect ODSP?
Hi, Fitz. That was one of my thoughts initially, as I was proceeding with the research on this. But in fact, the way it shakes out is that the income is received by the annuity, from the annuity by the trust. So it flows to the trust, and that doesn't affect ODSP, of course, because it's income to the trust. But you don't have to bother with paid or payable or preferred beneficiary election to attribute income. It's just automatically declared in the hands of the beneficiary. There's no option on the matter. Preferred beneficiary election is a choice that a trustee of a trust can make. In particular, if the beneficiary qualifies for the disability credit, there are some limited situations where the preferred beneficiary election applies even if the disability credit has not been applied or approved. But simplistically, if the beneficiary is approved for the disability credit, then the trust could be a qualifying disability trust if you decided you wanted to do that. And otherwise, what you would do is you'd make an election each year. So let's say that the trust is $400,000. It earns income at 4%, that's $16,000. You don't want it taxed in the hands of the trust, because even if it's a qualifying disability trust, it's taxed at 22%, which is tax. So what you want to do, unless you want to protect the GIS, is you make a preferred beneficiary election to attribute this to the beneficiary. So what you wind up with is a tax return that starts out with income of $16,000 and then attributes it to the beneficiary. So it then shows up on his tax return, but only shows up. It's not actually money. And the trust return is a nil return. It's zero because it's attributed all the income to the beneficiary. And the beneficiary has the personal and disability tax credits of $20,000, so there's no taxes owing. So it's a good technique.
I think this question was in regards to maybe when we were talking about annuity or pensions.
Yeah.
But they're asking, how do you prove or establish a possible shortened lifespan?
Well, it's up to the insurance company's doctors. But what you do is you get basically a doctor's letter or referral saying that the anticipated lifespan is less than normal. And then the doctors and the actuaries for the insurance or the annuity company, the insurance company which places the annuity, makes their own assessment based upon the physical aspects of the person. And this is really not something that has been canvassed very much. It's a fascinating topic. I'm really looking forward to this because, for example, I have a client family. They have two young adult daughters who are apart in years by about 1 or 2. And the one girl has Down syndrome, and the other one doesn't. And they have life insurance for both, although a lot of insurance companies simply decline to take an application from a person with disabilities, such as Down syndrome, because they're just not interested. And the difficulty of properly underwriting their life. But this policy did get issued after some effort. And of course, the premium and the coverage, the premium's higher and the coverage is less than her sister. So it was agreed that under some criteria that her lifespan was expected to be less. So this would be the flip side of that for the annuities. You would then seek to have a qualified annuity with an expected lifespan of some lesser amount. We're working on one right now where the brother happens to be a smoker and a heavy drinker. And so we will get his doctor to provide a letter saying that due to his drinking and smoking, he's expected to live a lesser lifespan. And then it'll be into the hands of the doctors for the insurance company, and we'll just see what the variance is on the annuity that's being purchased. I'm really looking forward to it.
How many Henson trusts can a person have?
There's no limit. You'd often have one from a grandparent, one from an aunt, never married, no kids, one from each parent, divorced, like that.
What is the best way to transfer ownership of real estate to a person on ODSP who is living in that home?
If they're competent, and if it's appropriate, you just put it in their name. They can own a home. They just can't carry it. But if you're in a position to be able to help them carry it, that's fine. You have to come up with some mechanism like retaining a 1% interest, partly so that they can't mortgage or sell it without your consent, but also so that you can legitimately pay some supplemental amount for the costs of the property without affecting their ODSP. I've only had a couple of cases where it was deemed to be appropriate to do this, to put it directly into the hands of the child, but it could be. They would, of course, be at risk if they married and then divorced, because they'd lose half of it. You can hedge your bets by giving them the property, and if you're, for example, you're putting a mortgage on it, plus you're providing the down payment, taking back a note or a promissory note or a mortgage for your full value of the money you put into it. So there's only the equity that's gradually accumulated. Or you could have a shared ownership arrangement if you wish. But of course, you'd prefer to have the maximum amount owned by the child for the principal residence capital gains exemption. You could have an inter vivos trust, and there is a type of trust that still would work, exclusive use shelter trust, that still would work to hold the trust, hold the property, and have it managed by trustees. And it would qualify for the principal residence exemption, but it would also be deemed to be their own property if they were married. But if your issue is that you want somebody else to be the trustee for them, then you could create this exclusive use shelter trust and have the property title in the name of the trustees. And this would deal with the problems if it was just in your own name and then you died and it was a deemed disposition and taxes owing and so on. Lots of questions, eh?
Yeah.
We got a really bright bunch. We don't normally get this number of questions.
Yeah, everybody's awake and engaged.
Yeah.
Do you want to go through a few more?
Yeah, sure.
Okay. If a person has money in a seg fund, does it count if a person applies for ODSP?
It would be exempt up to $100,000. And what we do is we deal with people who are, for example, receiving CPP disability, and CPP is always less than ODSP, and there's no drug coverage. But because they're by definition a worker, they have some savings. So we use this mechanism to exempt the assets and apply for ODSP. And then, of course, you still have to, well, if you're receiving CPP disability, you meet the ODSP disability test. There was a question here. Teacher with a dependent child
I was just reading that.
Yeah. Is there a place where I could get more information? Not really. My experience is that the teacher's website really doesn't tell you anything, but I'll tell you. And the bottom line is that there is a pension available for an adult dependent child of a teacher. Yeah.
Is a disability tax credit only applicable from the date that the disability is recognized and approved, or can it be claimed back the allowable 10 years?
Well, you can go back to birth, but you can only do the tax filing back 10, or the adjustment rather back 10. Often there's slippage. One of the things that we have to oversee when we do this is that the date is not the date that the doctor filled out the form. Because obviously, and if a child has autism, it's not the date the doctor filled out the form. And we could often go back, certainly more than 10 years or to birth, or, you get certain subjective negative reactions sometimes from CRA. Well, all infants can't manage things. Well, yeah, all right. But, you can certainly go back until the child is diagnosed at age 4, for example. There is no segregated trust. There's an answer question there.
If a parent leaves most of his assets in a Henson trust for his disabled child, can a brother or sister of the disabled child legally contest assets in the Henson trust?
I'm sorry, could you do that again, please? I was reading another question.
Yeah. So if a parent leaves most of the assets in the Henson trust for the disabled child, can siblings legally contest these assets that are designated in the Henson trust?
No, not unless you could show undue influence or lack of competence on the part of the parent.
So this person opened an RDSP when the child was under 18. Now they're 22.
Yeah.
The parent used to be the plan holder originally, and they're asking, should they change it now to the disabled adult?
Well, if the child is competent, you're supposed to change it to the adult. But then what you would do, of course, is you get power of attorney from that competent adult child and remain an account holder because, of course, you're wiser than they are. And if they're not competent, well, you're still the account holder if you're the parent. But if you're not the parent, your parents are deceased and you're the brother, then you would have to have either legal guardianship or power of attorney.
What is the difference between a seg fund and a seg trust?
There really is no segregated trust. You can have a segregated fund held in trust, but as a term, segregated trust, I'm not sure what that would be.
What criteria have to be met for a person to be considered the principal resident of a property?
Well, if they're ordinarily resident there, that would be good. But even if they have been ordinarily resident there for a short time and then go away for a short time, they're okay. But the principal residence is lost after, I'd have to double check to tell you the truth, but I think it's 1 year unless you get an exemption because you're renting it out for a period of time. There are limitations. But if the question is, well, how little can I be there? I'd have to talk to you in specific about that. I can't really give you legal advice like that on on a video. But if the person is ordinarily resident, regardless of how long they're there, if they're not there much, they're out of the country all but 6 months less a day, that sort of thing. Well, then clearly you're still resident. But I'd have to speak in specific about that.
Is there any recourse for a dependent adult child who works and earns more than 30 grand a year, but has to live on their own and struggling to meet living expenses?
Not that I'm aware of.
Other than the tax credit,
No. Tax credits, yeah. You're just you're just a poor person.
All right, should we say goodnight?
Yeah, I think so. Can the audience see these questions?
No.
Okay. Well, I want to thank everybody for their very strong involvement. It's very kind. Makes my life more interesting. And Liisa, did you want to say any closing words?
No, I found this whole seminar really fascinating, and just say thank you.
Okay, excellent. Well, I know that, everyone, I know that what you've received is, probably sort of swelled your head a little bit and you're about to explode. But other than that, thank you for coming. If you do have follow-up questions, feel free. If you haven't already signed up for the newsletter, do that, and you'll get monthly articles that are of interest. And thank you very much.
Good night, guys.
Night.